Hey everybody, John Skiba here from the Consumer Warrior YouTube channel. And this video is the first in a series of videos where I'm going to share with you all of my experience, tips, strategies, tactics, everything that I know about defending debt collection lawsuits. I'm going to share with you in this new series of videos. If you don't know me, my name is John Skiba. I'm founder of the Consumer Warrior YouTube channel, and I'm also an attorney in the state of Arizona where I help people who are being sued by debt collectors. I've been doing this for over 20 years. I've done over 400 trials, arbitrations, and everything in between when it comes to defending matters against debt collectors. And in this video series, I'm going to share all of that experience, all those years, all those late nights here in my office working. I'm going to share all of that with you so that you can have the best chance possible of leveling the playing field and being able to defeat the debt buyers who are filing the lawsuits against you. But if this is your first time here to my YouTube channel, please go ahead, click subscribe, check on that little bell. That way you'll be notified each and every day when I put out new videos like this that'll help you deal with serious debt problems. All right, so the way that we're going to do this series, I'm going to break it up into a series of videos that covers each stage of the litigation process, the debt collection lawsuit process. That way, we'll take you step by step through different processes, the things you need to submit, things that need to be filed. And it's important to note from the outset, while I am a licensed attorney in the state of Arizona, I'm not licensed anywhere else, and I also don't practice in any other states. So this isn't legal advice, but if you need legal advice, I recommend if you're in Arizona, my information's below, and you can get, set up a consultation with me to go over exactly what's going on in your case. If you're in another state, you can click below as well, and we'll help connect you with an attorney who does what I do in your state so that you can get legal advice that's specific to what it is you're dealing with. And I start with that, not only to tell you if you need legal advice, you need to talk to an attorney, but because things vary somewhat from state to state and the terminology can vary. So you might hear me use words like answer or complaint. Maybe it's called the petition and response in your state. And particularly when it comes to like timelines, like filing an answer or your response with the court, in many jurisdictions, it can vary as far as the number of days. Even if you're in the state of Arizona with me, it can vary depending on which court you're in. Whether you're in Justice Court, Superior Court, the rules are different, and so your approach needs to be dealt with somewhat differently. So the first thing I want to talk about though in our video today is kind of what gets the whole process going. Service of process. You've been served. And this is a little bit unsettling for most people because the process server is going to come by your house. They're going to literally knock on your door and they're going to place the summons and complaint in your hand. At least if it's being done properly, that's how it's going to play out. Literally someone's coming to your house and it feels really invasive. And I get it. You know what? They show up, you're sitting home watching TV, you're at dinner with the family or whatever, and all of a sudden there's someone there on your doorstep providing you legal documents. And the first thing people do is they panic and they go to this worst place in their mind as far as what's going to happen. What I want to do in this video, at least partially, is to help you to understand, look, if you put a plan together, a lot of that stress, a lot of that worry can go away. Not only that, nothing's going to happen immediately. You're going to see that the wheels of justice move very slowly when it comes to civil collection lawsuits like this. And so if you get served, and if you're watching this video and the first thing you did is go to Google or to YouTube to find out what to do, awesome. We're going to tell you what to do right here. The first thing you need to do, get out your phone and you need to put the date that you got served in there. It's going to be important because there's a lot of deadlines that flow from this date when they dropped off the complaint and the summons. So if you look at the summons that they provided you, is what summons you to court. It's what the court provides you information as far as what court this is being filed in, and then how much time you have to respond to the allegations in the complaint or the petition, depending on what they call it in your state. Now, the summons is going to tell you specifically. It's going to say you have 14 days or 20 days or 30 days or whatever it is. So, for example, in the state of Arizona, if you're sued in the Superior Court, you're going to have 20 days to file a written answer with the court. If it's the Justice Court in Arizona, same thing. You're going to have 20 days. If you live in a different state, though, it could be 30, it could be 14, it could be so you need to look at there and put that deadline in your phone. Create a little alarm for yourself to make sure you don't miss it. Because if you don't file a written response to the complaint and summons that you've just been served with, in many jurisdictions, you've defaulted and the case is over before it even started. So it's a super important date that you put into your phone and make sure that there's a reminder. If you don't have a phone, get out your calendar, circle it, make sure that date is something that you're fully aware of. Many times here in my law practice in Arizona, I'll ask people, when did you get served? And they say, I don't know, 2 weeks ago, 10 days ago, not sure. you're going to learn really quickly, and sometimes it's a painful lesson people learn, is that when it comes to the judicial process and this litigation process, they're serious as a heart attack about these deadlines. And if the deadline is 2 days from now and you file it 3 days from now, sometimes that's going to cost you, and it could cost you everything. You could lose your case entirely. So first step, from the date you got served, and if you're watching this video several days after, go back, figure out exactly when it was, and put that in your phone, put that on your calendar. Make sure that you know when your time frame is to respond, okay? So now that you know how much time you have to respond, you put that in your calendar, you know when you're going to file your response, let's talk about drafting the answer. Now, of all legal documents, I can tell you the answer is probably the most straightforward. It's vitally important to every debt collection case that you file a response to it, but it's something that most people who represent themselves are often called pro se or pro per, you'll see that. Most people can file the answer on their own. Now, I'm going to put some links below this video that'll have templates and even some tutorials on how you can do that. So don't worry about some of the logistics of it. We can kind of show you how to do that. But I want to talk about what goes into the answer, and maybe more importantly, what you need to keep out of the answer. Now, when you look at the complaint or the petition, whatever they call it in your state, you're going to see the top is going to have the caption. That's going to have the collector or the creditor's name versus you. And it's going to have your name there. And then it will have over on the right-hand side, it'll say complaint, or it'll say summons, whatever the document is, or a petition, whatever they're calling it. And then in the upper left-hand corner, you're going to see the name of the attorney's office who's representing the plaintiff or the creditor. And then what you're going to see below that is you're going to see a list of allegations that the creditor has against you. So that's the way to review the complaint. It's really just a set of allegations that this creditor, that this debt collector has against you. Doesn't mean they're true. It doesn't mean that they're accurate. They're just a set of allegations. And so what the answer or the response is that they are going to have you respond to the numbered paragraphs that are below the caption. So the caption again has the creditor's name versus you. Below that, there's these numbered paragraphs. And so what you need to do with the answer, all the answer is you going paragraph by paragraph and stating whether you admit, deny, or whether you lack sufficient information to respond to the allegations in that specific paragraph. Those are the three best answers. You admit the allegations that are in there, you deny the allegations that are contained in that paragraph, or you can say, I don't know, I lack sufficient information to be able to respond to it, so I'm going to deny it for now. Those are the three best answers. The biggest mistake, the number one mistake I see people make when they come to drafting their own answer is they often put way too much information in there. They go down past the we don't need to go at this point. All the court wants to know is essentially, do we have a dispute? Do the parties agree on everything? The creditor has put out all these allegations. Do you agree with everything? If so, there's no reason to delay this any further. We'll just grant judgment. But if it's something where there is a disagreement, do you admit that the junk debt buyer owns the debt? Do you deny it? Do you admit that you owe the debt? Is this an identity theft type issue? So those are the types of things that the court wants to know, is whether you admit or deny it, not, why you ended up in this. I see people who file their own answer, and often they'll put things like, they'll draft out, look, I lost my job, or I had a medical issue that resulted in me not being able to pay my credit card, and then it fell into collections. Or they, probably even worse yet, they go into settlement proposals. They're like, look, I'll go ahead and make a payment plan on this. And they're proposing things in the answer. Not needed, not appropriate, and could actually harm you in the end. So at this point, all we're doing is admitting or denying or saying we need more information to be able to respond to the debt collection lawsuit. Okay, so once you go through that, the numbered paragraphs, again, you admit, you deny, you're going through each of those and make sure you respond to them fully. Then you need to put what are called affirmative defenses. Affirmative defenses can be a little bit tricky, but a good way and probably an easier way to think about it, because we understand this more in the criminal context. So in a criminal case context, you can have something where someone is guilty or they'll plead guilty, but they have an excuse. Maybe there is insanity. That's one we see in movies all the time. They're guilty. They're saying, yep, I did this, but I shouldn't be held liable because I'm insane. Or I'm guilty, I shot the person, but I shouldn't be held liable because it was in self-defense. They were coming after me and I was just defending myself. Those are affirmative defenses in the criminal setting. In a civil setting, and particularly in a debt collection lawsuit setting like this, some type of affirmative defenses may be that what we call payment. Paid this debt and they're just not giving you appropriate credit for it. Or maybe you paid a portion of it and they're not giving you the appropriate credit for it in the complaint. So one of your affirmative defenses can be payment. Another big one is the statute of limitations. If they filed this lawsuit against you and you could say, look, I took out the credit card, the bills, I didn't make all the payments. However, I can't be held liable because it's outside the statute of limitations. Now, the statute of limitations is different for each state when it comes to credit card debt, written contracts, or oral contracts. However, if you're able to show or establish or at least prove or at least allege at this point that the statute may have been expired at the time when they filed this, you'll have a chance down the road to be able to establish that and provide more evidence as the discovery process moves forward. So those are the types of affirmative defenses we see in a civil case: statute of limitations, payment. Sometimes I will allege in mind that the case is subject to a private arbitration clause. We're going to go into what the arbitration process is and maybe how you can get it out of court and into arbitration. But I will often put that in there as well, just stating, look, even if I owe on this debt, it's subject to arbitration and it should be dealt with through the private arbitration process. So that's really just kind of big picture. Again, I'll put some links below as far as tutorials and templates and things like that can help you really dive deep into filing the answer and getting the answer drafted and submitted to the court. But that's kind of big picture of what you're looking at when it comes to a debt collection lawsuit and filing an answer to it. Filing the answer is super important. It's probably the number one thing you can do to get yourself on the right track to even have a chance of winning your case. 95% of people who get sued nationally by a debt collector don't file a response. And when they don't file a response, they end up with a default judgment, and that results in wage garnishment, bank levies, and everything else. So that's why it's so important that you take the time to know when you got served, draft the answer, and then get it timely filed. And that's where we're going to jump into next, is getting the answer filed. Now, where you file the answer, people may say, okay, I've got this drafted, now what do I do with it? You have to file it with the court. And so you can look again on the summons and also on the complaint or the petition. At the very top of the first page in the middle, it's going to tell you where the court's at. If you're not sure where it's at, you can see their name, Google them, give them a call, and see where it is that you need to file the answer with the court. Now, I always say take the original and make 2 copies of it after you've signed it and take those to the court. Because when you go to the court, one, you need to be prepared to pay a filing fee. Almost every court in the country, they're going to charge you some type of fee to file the case. If you need to know what that is ahead of time, give them a call, talk to the clerk of the court, say, hey, I'm coming to file an answer in a civil case. How much is that filing fee going to be? So you can be prepared to do that. And then you take the original and 2 copies with you down to the court, file the original with the clerk, and then have them date stamp the other 2 copies so you can take them with you. The reason why you need 2 copies is because you're going to mail one to the attorney for the debt collector, and then you're going to have one that you're going to keep in your own records so that you have proof that you filed the answer, and it'll have the date at the top and that you filed it timely. Now, it's important too to mail it. In most jurisdictions, the court is not going to mail or notify the other party that you have filed this answer. So I've seen it where people go down, they draft the answer, they file it with the court, but then they don't send a copy to the other attorney, and then the other side files a default because they're unaware that you actually filed the answer with the court. So it's important that you send the other attorney's office a copy. You can send it through the mail. Most times you do not need to file or mail it like certified mail or anything like that. I can tell you in general, attorneys do not do that. We don't mail things certified just because we do it in huge volume and the cost would get too great. If you want to send it certified, you can do that just so that at least with the tracking number so that you know that it actually got submitted to the court. So that's how you get it filed. And that's going to make it so that as long as you did it timely, that you're not running into any kind of default issues where the court's just going to give them everything they ask for. Because that's what happens. If you don't file the answer, the court just assumes that you agree with what they're saying. They give them the full amount that they're seeking, plus attorney's fees, plus court costs, and it turns into a whole giant thing. So that's how you deal with the answer. Now, any of you who've watched my channel over the years, you know that I am a big proponent of seeking private arbitration instead of dealing with this matter through the court system. Now, let's talk about what that is. In the credit card type lawsuit, they have a thing called the terms and conditions of the credit card. This is, the paperwork that when you get a credit card that they send you in the mail or they email you that we all say that we've looked at when we really usually just throw it away. But it's important because it has the terms and conditions that govern your credit card as well as any subsequent buyer of the debt. So if you're dealing with a junk debt buyer, like a portfolio recovery, LVNV funding, they're alleging they bought the debt, they're bound by those same terms as the original creditor had. And so what you need to do is when you first get served with a credit card debt, something you need to find out is if the debt is subject to a private arbitration clause. Now, you may be asking yourself, how in the world am I going to find that out? Sometimes the first way you can do it is, in many instances, the law firm will attach a copy of the terms and conditions for the credit card to the complaint that you're initially served with. If they did that, if it's attached as an exhibit, you need to go through there and look through that line by line. Now, the arbitration clause in almost every terms and conditions on a credit card, it's usually in all caps, bold. It's something you're going to be able to see, and it's usually towards the end. If it says that there's an arbitration clause in there, that means that you're going to be able to pursue the matter through private arbitration rather than through the court process. Now, you're probably asking, what if my complaint that I received or the petition that I received, what if it doesn't have a copy of that? You're in luck. You can go to the Consumer Financial Protection Bureau. This is a government agency. They actually keep a whole database of all terms and conditions for credit cards online, free to the public. I'm going to put a link below so that you can go there and search for your specific terms and conditions for your credit card. I'll even do another little video to show you how you can do that, how you can find that so that you can pull that up, print that off, and see if your account is subject to an arbitration clause. I can tell you this, most credit cards are subject to an arbitration clause that's going to be binding again on any subsequent purchaser of that debt, like a junk debt buyer. Okay, so once you have that and you notice, okay, it's subject to an arbitration clause, that's when you can use this to your advantage to put yourself in a better situation to litigate this case. Let me give you a little bit more. Let's step back just a little bit to talk about what a private arbitration clause is and what private arbitration is. So this lawsuit is filed in the judicial system. You're having a judge, a government employee, who's been appointed or is elected to be able to deal with your case. Arbitration, private arbitration, is a situation dealt with through a private company. Now, there's two big private arbitrators in the United States. There's AAA, the American Arbitration Association, and there's also JAMS. These are the two big players when it comes to private arbitration. They are private companies. They have these arbitrators who are kind of quasi-judges of sorts who will be able to hear your case, and it will have a binding ruling upon the parties. The arbitration clause in your credit card agreement gives you the option, it also gives the creditor the option, but it gives you the option as well of having the matter taken out of the court system and put into the private arbitration system. Now, you may be asking yourself, why in the world do I care whether I'm fighting them in a private arbitration or whether I'm fighting them through the judicial system? There's a lot of benefits to being in the private arbitration system. One is that if you can get it out of the judicial system and deal with it through the arbitration system, one is that the creditor does not want to be there in most situations. Fighting this case in court, they didn't have to pay very much at all. They had to pay their court filing fee. They had to pay to have a process server come by and serve you. However, if you go into private arbitration, like AAA with the American Arbitration Association, the filing fees for you as the consumer and for them as the creditor are vastly different. And in most consumer cases, the creditor, the company, their filing fee can be in the thousands of dollars, $2,000 to $3,000 that they have to pay up front for the privilege of suing you and having the matter dealt with in private arbitration. Whereas the filing fee for you as the consumer is often around $200. So you can see if they're suing you for $1,500 and you move to have this case dealt with in private arbitration, they're not going to pay $2,000 to avoid having for the right to be able to take you to arbitration and hopefully collect $1,500. Not only that, in many arbitration clauses contained in those terms and conditions, it will actually say that they can't come after you for any of the fees associated with the arbitration process. So because of this, you can put yourself in a much better situation to either get a settlement or to get the matter resolved and dismissed completely. So then the question is, how do you get from the court where the creditor filed it, how do you get your case into the arbitration realm? And how you do it is you need to file a motion to compel private arbitration. Now this can be done. You can file your motion even before you file your answer, or you can file it after you file your answer. Most arbitration clauses that deal with credit cards state that you can file a motion to ask the court to push the case into private arbitration at any time before a judgment is entered or even right up until the trial starts. Now, here's some of my pro tips here. If you're going to push this into arbitration, you should do it as soon as possible. I often will even do it before I file the answer. I'll file a motion to dismiss and compel arbitration, or just a motion to compel private arbitration. You're required to attach a copy of that arbitration clause to show the court, hey, judge, this is subject to arbitration. This is where I'd like it to be. Now, you can file the answer if you want, and then file it just to make sure that there's no issues. Because if for whatever reason the motion to compel arbitration is denied, you then still have to file an answer. You have to respond to those allegations in the complaint. So a lot of times, just to be safe, if you're unsure of this or you're a little worried about the whole process, I say just file the answer and then turn around and file a motion to compel arbitration. Now, in most situations, the motion to compel arbitration should be granted. This is the contract of the creditor. You're not asking the court to do anything but enforce the very terms that the creditor is trying to enforce against you. So file the motion to compel arbitration, and then once the court grants that, you need to be prepared to move forward with that. I usually recommend actually going ahead and reaching out to the American Arbitration Association and just filing that case with them and being prepared to move forward. The creditor's not going to do it. They don't want to be there. And if you don't do it, they'll often go back to the court and say, hey, judge, they didn't file their private arbitration. Let's just deal with this in the court. The best way to deal with that is just to say, you know what, file it, and that'll put the whole case in there, and then you can deal with that going forward. So that's how arbitration can help you. We will dive a little bit deeper into that in some of our future videos as far as the arbitration process, and I'll put some additional links. I have a really deep dive tutorial that'll show you how to do it, why the process overall, and even have a template for you. So I'll put a link down there below if you want to check that out. But that's going to be your alternative, or in addition to the answer that you've already filed with the court, is your motion to compel arbitration. Okay, so that is the overall process for filing the answer, whether you're filing the answer, you're doing arbitration, or whether you're doing both of them together. This is a key, a super vital part of your case. You can't miss this part. If you don't do this part correctly, if you don't file the answer correctly, you're going to end up with a default judgment. And once the default judgment's already been entered, very difficult to unwind. So again, the main things you need to take away is make sure that you write down the date that you were served, look on the summons and see how much time you have to respond to the complaint and the summons, and make sure that you do it timely. When you're drafting your answer, don't put too much information in there. You need to respond to it accurately. You need to be honest in this completely. But I also say you need to be painfully honest. What do I mean by that? If they're saying that you owe $5,610 and you don't have an independent understanding of how they came up with that number, it's okay to say that you lack sufficient information as to that paragraph and therefore you deny it. You need to make sure that they didn't draft their complaint in a clear way and it leads to confusion or leads to different possible interpretations. It's okay to say that you lack sufficient information. You need to be accurate. You need to be honest in your submission to the court. But again, you shouldn't just assume because what they drafted is unclear that it's accurate. So that's what I mean by being painfully honest or painfully accurate as you're going through there. So making sure that you get that submitted timely and then mail a copy to the other side so that you don't end up with any type of default. And then again, if you file a motion to compel arbitration and you get that pushed into JAMS or the American Arbitration Association, you need to be prepared to move forward with it. So hopefully that's helpful as we are beginning this process of how to deal with a debt collection lawsuit. Again, I'm going to give you all 20 plus years of experience that I have in dealing with debt collectors and junk debt buyers and trying to help get this thing out of your life and in the rearview mirror. In our next video, we're going to talk about disclosures and the discovery process as far as exchanging information and getting documents from the creditor and them trying to get it from you. So hopefully this is helpful. Again, check out the links below for the different templates, tutorials that I have to do a little bit deeper dive into some of those areas, and we'll catch you on the next video.